morning. This is Raymond De Leon, and today I have another 1983 special for you guys. Yesterday in the comment section, somebody had asked me a question about the Brady violations and does it penetrate or pierce the doctrine of qualified immunity. I'm going to define what qualified immunity is. I'm going to let you know if it pierces qualified immunity, and I'm going to show you the instances where qualified immunity does shield the state agent, official, or police officer. But before we get into that, I just want to let you guys know that if anyone is interested in contacting me, you can contact me in the description box of this video and of all my prior videos by either clicking the Facebook link or clicking the Messenger link so that you can directly message me. Look inside the description box to this video. If anyone is interested in furthering their knowledge on any of these topics and would like to talk to me in private, you can call me directly on Messenger. You can also become a member of the Smooth Operation of Law team by taking our course to become a trustee of Smooth Operation of Law's trust, and once trained in protecting our assets, you can then work as a member of the Smooth Operation of Law team. There is a course that you must take, which is your on-the-job training taught by a trustee to do your duty as a trustee. Now, anyone that has any questions about today's class, go ahead and put your comments directly to me on that Messenger, that Facebook link. I will be accepting your friend request. And you can also put a comment down below on this video. All right, now let's get into this. Qualified immunity. In the United States, qualified immunity is a legal principle that grants government officials performing discretionary functions immunity from civil suits unless the plaintiff shows that the official violated clearly established statutory or constitutional rights, of which a reasonable person would have known. It is a form of sovereign immunity less strict than absolute immunity that is intended to protect officials who make reasonable but mistaken judgments about open legal questions, extending to all officials but the plainly incompetent or those who knowingly violated the law. Qualified immunity applies only to government officials in civil litigation and does not protect the government itself from suits arising from officials' actions. The U.S. Supreme Court first introduced qualified immunity doctrine in Pearson v. Ray, 1967, enacted during the height of the civil rights movement. It is stated to have been originally enacted with the rationale of protecting law enforcement officials from frivolous lawsuits and financial liability in cases where they acted in good faith in unclear legal situations. Starting around 2005, the courts increasingly applied the doctrine to cases involving the use of excessive or deadly force by police, leading to widespread criticism that it, as summarized in a 2020 Reuters report, has become a nearly fail-safe tool to let police brutality go unpunished and deny victims their constitutional rights. Okay, so let's look at the application. Okay, it applies to discretionary function requirements. Qualified immunity also applies to acts that are discretionary rather than ministerial. Courts specifically distinguish discretionary acts from ministerial acts. A discretionary act requires an official to determine whether an act should be done or a course pursued, and to determine the best means of achieving the chosen objective. By contrast, ministerial acts is of a clerical nature. The official is typically required to perform the action regardless of his own opinion. Even ministerial tasks will sometimes involve a small amount of discretion, but the discretion will not necessarily satisfy the requirements of qualified immunity. Clearly established law requirement. Qualified immunity does not protect officials who violate clearly established statutory or constitutional rights, of which reasonable person would have known. This is an objective standard, meaning that the standard does not depend on the subjective state of mind of the official, but rather on whether a reasonable person would determine that the relevant conduct violated clearly established law. Whether the law is clearly established depends on whether the case has addressed a disputed issue or has established the contours of the right, such that it is clear that the official's conduct is illegal. It is undisputed that Supreme Court opinions can clearly establish the rule for which in the entire country. However, Circuit Court of Appeals opinions may have a more limited effect. Circuit Courts of Appeals typically treat their opinions as clearly establishing the law within that circuit, though the Supreme Court has cast doubt on this theory. In order to meet the requirement of clearly established law, the facts of the instant case must also fairly closely resemble the facts of the case relied on in the precedent. Then there's qualified immunity sequencing. And I'm not going to bore you with any more. It's just these are important, very important paragraphs to read in order to paint the scope. Qualified immunity sequencing. The concept of testing whether the official action was covered by qualified immunity was first raised in 1991 case Seigert versus Gilley, in which the Supreme Court affirmed a dismissal of a lawsuit due to lack of clear demonstration that a constitutional right had been violated at the time of the action as a necessary precursor for any judicial relief. In 2001, the Supreme Court in Saucier versus Katz formalized this rigid order or sequencing in which courts must decide the merits of the defendant's qualified immunity defense. First, the court determines whether the complaint states a constitutional violation. If so, the next sequential step is to determine whether the right at issue was clearly established at the time of the official's conduct. The court subsequently modified the mandatory sequencing from Saucier in Pearson versus Callahan in 2009, holding that the Saucier protocol should not be regarded as mandatory in all cases, and that its decisions does not prevent the lower courts from following the Saucier procedure. It simply recognizes that the courts should have the discretion to decide whether the procedure is worthwhile in a particular case. The Pearson opinion gave courts the discretion to evaluate either a constitutional violation or the rights issues first. That can have benefits of expanding some cases and reducing waste of resource in the court systems, but has also led to cases that focus heavily on one side of the case and weigh in favor of government officials, particularly in the area of police brutality. All right. So the big deal and the big thing that really gets to the heart of the question about qualified immunity, according to yesterday's video based on the Brady violations, and if Brady violations will pierce qualified immunity, can be found with what I'm about to read to you right here, right now, on screen. Okay, so this comes from the circuit judge in 2018, okay, and it's the Fifth Circuit of Appeals found that the Texas Medical Board was entitled to qualified immunity for an unconstitutional warrantless search it made of a doctor's patient records. Willett called the thoughtful reappraisal of the clearly established law prong of qualified immunity analysis, citing a tendency for many courts to grant immunity based on no clear precedent, while avoiding the question of whether a constitutional violation has occurred. Hence, those courts do not establish new law. So wrongs are not righted and wrongdoers are not reproached, he wrote. To some observers, qualified immunity smacks of unqualified impunity, letting public officials duck consequences for bad behavior, no matter how palpably unreasonable, as long as they were the first to behave badly. Merely proving a constitutional deprivation doesn't cut it. Plaintiffs must cite functionally identical precedent that places the legal question beyond debate to every reasonable officer. Put differently, it's immaterial that someone acts unconstitutionally if no prior case held such misconduct unlawful. Current yes harm, no foul imbalance leaves victims violated but not vindicated. Section 1983 meets a catch-22. Important constitutional questions go unanswered precisely because those questions are not yet answered. Courts then rely on that judicial silence to conclude there's no equivalent case on the books. No precedent, no clear established law, no liability. An Assyrian stairwell. Heads government wins. Tails, plaintiff loses. So now, this is where, the interpretation of qualified immunity can be seen as having a huge shielding, because pretty much if there's not a case that already states that the act and nature of the facts or behavior of that agent of the state has already been established as illegal, therefore not allowing for those judges in lower courts to have to even look at the constitutional question or the facts. And they can unilaterally just say, well, there's nothing for us to go for because there's no direction for us to evaluate the new situation. Therefore, not allowing for any growth in government to protect our constitutional violations. It almost puts a cap on no new claims for tomorrow based on new acts that could be constitutionally questionable. We can only measure everybody that works for our state based on yesterday's arguments, and if somehow your today injury meets similarities with yesterday's argument. With that being said, this was literally yesterday's argument. You guys got to give me a second here. It's going to load. What the fuck? Okay. Here we are. So we yesterday talked about, can I sue a police officer for Brady violations? for concealment, doctoring, or destruction of evidence. Well, in what I was reading yesterday, Brady versus Maryland would be that Supreme Court case that addresses whether you can sue a police officer for Brady violations. That is exactly why I brought up the case Brady, as opposed to just saying, well, under Title 42, Section 1983, you can sue for a deprivation of rights under color of law. Deprivation of rights under color of law is supposed to protect you from state actors who act under color of law. And it's supposed to prevent or allow you to be compensated for any actions that violate constitutional questions. The problem with qualified immunity is that it almost puts a constraint on certain constitutional questions, allowing the judges to avoid if there is no direction via a pre-litigated case. In the case of Brady versus Maryland, that would be a pre-litigated case. With that being said, when I was asked in the questions, what about qualified immunity? I appreciate that question, and that question is awesome. And it brought up a great point into giving context as to how potent would Brady violations be considered in a court. Awesome question to that guy in the comments. Awesome question. Yeah, my screen just cut off, so I had to attach a secondary video. So when I was reading yesterday, what is Brady and what is a Brady violation, okay, I read the Supreme Court case, or the definition, that the Supreme Court held that the suppression by the prosecution of evidence favorable to the accused upon request violates due process where the evidence is material to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. It's been decided. The Supreme Court expanded Brady, holding the duty to disclose such evidence is applicable even though there has been no request by the accused in the United States versus Eggers, or whatever. And there are a list of cases, and more cases, and more cases, which stipulate the legal precedents for the nature of your argument when it comes to Brady violations. If anybody is questioning anything further, please leave it in the comments. I enjoy it. And there are other scenarios where qualified immunity can be pierced. But just remember that for the most part, they must have a legal precedence in order for your constitutional question to be observed. We can go through what ifs, find out if. To answer your own what if, there is a question already answered with case doctrine. Now, for those of you who might want to get in contact with me, just hit me up on Messenger and Facebook. If you want to be a part of the Smooth Operational Law team and get some OJT on protecting assets of the trust, usually we deal in intellectual property of our trust, and anything else in the description is a trade secret, so I can't even say it here, then you can become part of our information-based trust. What I need for you guys to do is please like, subscribe, share, fill up the comment section, and hit me up on Facebook. Hit me up on Messenger. If you have a group of people who you may be wondering the same type of questions that are surrounding some of the topics that I instruct when I'm talking on these videos, you can go ahead and hit me up with the entire team, and maybe I'll use a Zoom. Good morning, and have a great day. And I hope I talk slow enough, because in real life I actually talk too fast. So I hope everything that I'm saying is clear. Oh, and for the individual that left a comment about my microphone, outstanding. I hope today's microphone worked better.